good evening, students. Here I am. I am starting the Sabarimala case series. As we know that in the last 1 or 2 years, there have been a lot of contentious issues with respect to law, religion, and constitution. And definitely, Sabarimala is a trailblazer in this area. And so, starting with the first case, as we know, for your information, I want to share that the main case in which the PIL was filed in the Supreme Court was Indian Young Lawyers Association versus State of Kerala. This was the main case in which there was a five-judge bench, and the majority judgment, that is judgment by Chief Justice Deepak Mishra, along with Justice Nariman and Justice Chandrachud, along with Justice Khanvilkar as well. These four judges, they gave the majority opinion, and Justice Indu Malhotra, the single woman judge on the bench, she gave the dissenting opinion. Now, the majority opinion said basically that this exclusionary practice, that is the practice of excluding women from entering into the temple and also from worshipping Lord Ayappa, this is discriminatory. Thus, it is violative of Article 14. And especially, as I will again describe later in this session, Justice Chandrachud also held that this practice of excluding women is also one form of untouchability, thus violating Article 17 as well. So, friends, Justice Indu Malhotra, the lone dissenting woman judge on the bench, she rather surprisingly came out with a very stern ratio, what we call that, however irrational or illogical a religious practice may be, but the court is no one to question that particular practice. Thus, that since the practice is a religious practice, it is within the ken of the leaders of that particular religion, of the scholars, and of all the clergymen of that particular religion. And a court of law, which is supposed to be a secular institution, it has nothing to do, absolutely, with any form of religious practice or questioning its rationality or logical bias. So, friends, moving to the first aspect of the case. Next slide. Yeah. Before moving, friends, I just want to just wipe up the first this Article 25. Yes, friends, I hope you are clear with Article 25. Basically, before moving to the merits, I just want to make it clear that the concept of secularism, friends, we have heard a lot of times this concept of secularism in the political discourse of the country, in TV debates, and generally people are people say that secularism simply means separation of religion from state. Now, it is a very prima facie understanding of the wide concept and a very deep concept called secularism. Definitely, secularism is a word which basically means secular. That means you secure yourself from the various religions. You are something outside religion. So it is normally seen something beyond and outside religion, something different from religion. And thus, there were two schools of thought in the Western philosophy. One, which was definitely towards the religion side, which the torchbearer of this religious school of law was Saint Augustine and Thomas Aquinas as well, who said that law is nothing but a dictate of God, and man is only a manager. The king is only a kind of a manager of that particular dictate of God who has to administer. Yeah, now is it clear, Shashwata? Am I audible right now? Okay. Yeah. So, as per the religious school of thought in the Western political philosophy, this particular notion was prevailing that law is nothing but the dictate of God, and king is nothing but a manager who has to administer that dictate of God and administer to human conduct. But there was again a new school of thought which specially came after the Renaissance, what we call the Enlightenment age or Enlightenment period. You will also mark that most of the inventions, that is Newton's three laws and all the Albert Einstein definitely later, in between all the inventions, it all started around 16th century and it lasted up to 19th and 20th century. This was the period which was called, okay, this was the particular period, these 4 or 5 centuries, this period was called the Age of Enlightenment in the European history. And they emphasized more on logic, more on rationality, and not on religious, illogical things and religious biases. So there were two schools of thought. And And then the concept of secularism arose. That is, anyone who is different or who is outside the religion, who is outside the religious biasness, and as Karl Marx also said, that religion is nothing but opium. It's like a opium. So, who is outside that madness of opium is a secular person, is a secular institution. Now, Indian secularism is absolutely different. If I can just switch on to the next slide. Next slide, please. Akhilesh, sir, next slide. Yeah. Okay. Right. Friends, if you just focus, if you just see my cursor, if you can see my mouse cursor, you can read from here. Just here. Yeah. Therefore, it is clear. This is the speech of H.V. Kamath, a very reputed person who was a member of the Constituent Assembly of India, and this is from volume 8. These debates are from volume 8, which happened on 6th of December 1948. So, if you can read from here, therefore, it is clear to me, to my mind, that if a state identifies itself with any particular religion, there will be rift within the state. After all, the state represents all the people who live within its territories, and thus it cannot afford to identify itself with the religion of any particular section of the population. But, sir, let me not be misunderstood. When I say that a state should not identify itself with any particular religion, I do not mean to say that a state should be anti religious or irreligious. We have certainly declared that India would be a secular state. But to my mind, a secular state is neither a godless state nor an irreligious nor anti religious state. Thus, the precise understanding that one can gather from this beautiful passage is that secularism, especially in the Indian aspect, in the Indian context, it does not mean a divorce. It does not mean a detachment between state and people or between state and religion. It rather means a holistic understanding of state and religion, where state is not irreligious, not anti-religious, neither is outside the religious domain. Rather, state will facilitate each and every person to practice, profess, and propagate his or her own religion. If I can simplify in Hindi also, that state कभी भी आपके रिलीजन के खिलाफ नहीं है. स्टेट कभी भी ये नहीं चाहता कि आप इस रिलीजन को फॉलो ना करें या इस रिलीजन को फॉलो करें. स्टेट कुछ भी नहीं बोलेगा आपको कि आप इस रिलीजन को देखें या उसको ना देखें. इट्स ऑल अपॉन यू. बट यस, अगर फॉर एग्जाम्पल, एक बेसिक एग्जाम्पल, अगर आपको दुर्गा पूजा करना है, then definitely, or thoda, it's a kind of public ritual, or it's a kind of public, it needs a public procession. Durga Puja, yeah, Ganesh Puja, it all needs public procession, it all needs public pomp. So definitely you can give an application to the local magistrate or the local police. I can ask that, sir, from this time to this time we will carry a procession, and please kindly provide the security. So this is an example where state facilitates your right to practice religion. Here, state will never say you can't do it because it's a fundamental right in Article 25 Clause 1. But again, you also can't say that the state, by providing security to your procession, is promoting Hindu religion. Similarly, in Muharram processions, in the Muslim people, in their processions also, definitely the state, by providing security to them, does not promote Muslim religion. So, state is a facilitator. We know that under the Indian constitution, the Indian state is a welfare state. And as per a welfare state, the state is treated to be a facilitator of all your wishes and all your ends. Thus, by facilitating your right to practice or propagate religion, state is not becoming an agent to promote that religion. Rather, state is actually protecting your right to propagate or practice that religion. In simple terms, this is the understanding of Indian secularism. And that's why Swami Vivekananda also in his Chicago speech said that in India you can't divorce Indian life from religion. If I can just go to the next slide, I will have that particular line also. Yes, uh, just here it has been argued that by conferring additional right. Yeah, if you can just see here, it has been. If you just follow my mouse cursor, It has been further argued that by conferring the additional right to propagate a particular faith or religion, the door is opened for all manner of troubles and conflicts which would eventually paralyze the normal life of the state. I would say at once that this conception of a secular state is wholly wrong. By secular state, as I understand it, it means that the state is not going to make any discrimination whatsoever on the ground of religion or community against any person professing any particular form of religious faith. This means, in essence, that no particular religion in the state will receive any state patronage whatsoever. The state is not going not going to. Next slide, please. Yeah, just follow the mouse cursor. The state is not going to establish, patronize, or endow any particular religion to the exclusion of or in preference to others, and that no citizen in the state will have any preferential treatment or will be discriminated against simply on the ground that he professed a particular form of religion. In other words, in the affairs of the state, the professing of any particular religion will not be taken into consideration at all. This I consider to be the essence of a secular state. At the same time, we must be very careful to see that this land of ours, we do not deny to anybody the right not only to profess or practice, but also to propagate any particular religion. Mr. Vice President, this glorious land of ours is nothing if it does not stand for lofty religious and spiritual concepts and ideals. I just want to focus here, right, just in these lines. Mr. Vice President, this glorious land of ours is nothing if it does not stand for lofty religious and spiritual concepts and ideals. India would not be occupying any place of honor on this globe if she had not reached that spiritual height which she did in her glorious past. Therefore, I feel that the Constitution has rightly provided for this not only as a right but also as a fundamental right. In the exercise of this fundamental right, every community inhabiting this state professing a religion will have equal right and equal facilities to do whatever it likes in accordance with its religion, provided it does not clash with the conditions laid down here. So basically, friends, here it is said that Indian life, Indian एक average Indian का जो life है, it is very much associated with religious practices. Whether आप हिंदुइज्म देख लें, whether मुस्लिम लोगों का भी देख लें, दिन भर वो 5 बार नमाज पढ़ते हैं, तो Indian life is completely associated and completely mixed with religion. You can't divorce Indian life from religion. अगर लोगों को आप रिलीजन से डाइवोर्स नहीं कर सकते तो स्टेट का कैरेक्टर भी एब्सोल्यूट डाइवोर्स नहीं कर सकता क्योंकि स्टेट इज नथिंग बट अ रिफ्लेक्शन ऑफ द सोसाइटी. स्टेट इज एन एजेंट टू कंट्रोल एंड टू regulate the society. If the society is a diverse society, if the society is such that religion is very prime importance of the society, then religion will also find an important place in the policies of that state which governs the society. अमेरिका में बिकॉज वी नो दैट द वेस्टर्न वर्ल्ड इज अ मटेरियलिस्टिक वर्ल्ड. जितने भी रिलीजन्स है दे हैव नॉट ओरिजिनेटेड इन यूरोप except Christianity definitely. The other major religions, Muslim, Islam, whether we take Hinduism, whether we take Buddhism, Jainism, they have found their origin in this particular land. And as we know that in from 16th century to 20th century, there was an age of enlightenment in the European world where the focus was to leave religion and to emphasize rationality, to leave the religious logic and emphasize the rational logic, that is the material logic. That's why that's why industrialization also took place, because industrialization is nothing but a materialistic interest. Industries they did not pursue any religious interest. Industries pursued their own material economic interests. Therefore, secularism in the Western world has to be different from secularism in the Indian context. I hope this concept is clear that Indian secularism is absolutely different from Western secularism, and that's why you will find in Article 25 the best example, if I may just read in Article 25, which provides that nothing in this article shall affect the operation of an existing law or prevent the state from making any law, providing for social welfare and reform, or throwing open of Hindu religious institutions to all classes and sections of Hindus. बेसिकली कोई भी स्टेट को मना नहीं कर सकता फ्रॉम ओपनिंग one particular Hindu temple or one particular Hindu institution, which is a public character, provided a public temple, hai, a public institution, hai, to all the sections and all the communities of Hindus. This is one example where state actually it directly, no, I would not say, I would not use the term interfere, but it directly regulates the particular religion, and it actually encourages other person to follow Hindu religion. By this, the state does not promote Hindu religion, rather it is providing them opportunity who were deprived. पहले जो भी लोग जो अनटचेबल थे, जो जिनको अछूत बोलते थे, और जो नीचे जाति के थे, जो शूद्र थे, they were not allowed to enter into any temple. They were also not allowed even moving near the temple premises. उनके लिए अलग जगह होता था बैठने का, उनके लिए अलग बर्तन होते थे खाने के लिए, उनके लिए सब कुछ अलग होता था. इवन पब्लिक वेल, गांव में जो टैंक्स होता है, जो वेल्स होता है, उनके लिए वो अलग थे. तो ये जो प्रोविजन है कि जो भी हिंदू टेम्पल पब्लिक कैरेक्टर का टेम्पल है या पब्लिक कैरेक्टर का हिंदू इंस्टीट्यूशन है, दैट विल बी ओपन टू ऑल सेक्शंस एंड ऑल कम्युनिटीज ऑफ हिंदूज. अगर स्टेट ऐसा कोई लॉ बनाता है, वेस्टर्न पीपल माइट से दैट द स्टेट इज इंटरफेयरिंग इन रिलीजन रादर प्रमोटिंग हिंदू रिलीजन. बट अगर इंडियन सेक्युलरिज्म के पर्सपेक्टिव से देखें तो ये प्रमोटिंग हिंदू रिलीजन नहीं है. ये स्टेट रादर उन डिप्राइव्ड क्लासेस को उनका पुराना खोया हुआ अपॉर्चुनिटी दे रहा है कि आप फिर से मेन स्ट्रीम सोसाइटी में वापस आइए, सबके साथ मिलिए और रहिए. एंड दे आर एक्चुअली, द स्टेट इज एक्चुअली गिविंग देम दैट एक्सेस ऑफ विच दे वर डिप्राइव्ड इन द पास्ट टाइम्स. So I hope in a holistic manner I've tried to understand the Indian version of secularism and its practical example in Article 25 Clause 2B. So friends, now moving, this was the philosophical background of the right to religion, the right to practice, profess and propagate religion, and thus we shall move to the case directly right now. So if I can just go to the next slide. The next slide again. Yeah. So, friends, now coming to the facts of the case. Now, just let us now basically understand the facts क्या है केस का. Firstly, Lord Ayappa. Just to because no, the previous slide. Yeah, this one. Fine. Lord Ayappa is a Naistika Brahmachari. Brahmachari means in English we say Brahmachari means celibate. Celibacy means abstinence from sexual intercourse. But brahmachari simply does not mean abstinence from sexual intercourse. Brahmachari is much wider concept than that. Definitely, a person should not engage in sexual intercourse. That is one. Then he also, as I will again explain you later, that a person should not also come into contact with the woman of his or her own house, except the mother. Definitely, the person should cook his own meal. There are various other requirements, especially with respect to Lord Ayappa's worship, which are required for a person worship Lord Ayappa. As you can just read this line, that Lord Ayappa's worshipper, just follow my mouse cursor, Lord Ayappa's worshippers and devotees have to follow a 41 days course of vratam. That is a vrat. In Hindi we call it vrat. That is a kind of, we generally associate it with fast. Vrat is simply an oath. So anyone who wants to worship Lord Ayappa has to follow this 41 days of vrat. And what is the vrat about? I'll just explain you later. Just now, if you can just read this particular para, which explains the process. That first, there are 4 stages of worship. You have to formally engage in an initiation ceremony, जो 41 day व्रत को start करता है. Then ये वही है. If you just give a bare reading, it's as simple as English language. This stage includes the physical travel. You have to go to the pilgrimage site. ठीक है. फिर pilgrimage site में you have to again take bath in a river, that is river Pampa, at the foot of that Mount Sabri. और वो जो mountain Sabri है, उसके चोटी पे, at the hilltop of Mount Sabri, there is the temple of Lord Ayappa. So there are 3 to 4 stages basically. पहले आपको 41 days का व्रत फॉलो करना है. 41 days के व्रत के बाद that is the first stage. You have to again start an initiation ceremony. एक धागा बांधोगे आप, ये first stage हो गया. Then you will move out. You will go to the foothills of that particular mountain, जिसके hilltop पे लॉर्ड अयप्पा का मंदिर है. वो mountain पे पहुंचोगे. Mountain पे पहुंचने से second stage हो गया. फिर mountain के पास you have to take a bath in the holy river Pampa, and then you have to start climbing the mountain. That is the third stage. The moment you reach the top of the mountain, the third stage gets over. You worship Lord Ayappa, and the return journey is the fourth stage. And the moment you return to your home after worshipping Lord Ayappa, the fourth stage gets over. So, friends, I hope this was very simple process as explained in the judgment also. So, just if I can move to the next slide. Yeah. Now, this was about the facts of the Sabarimala temple and how the worship took place. Now, coming to the facts of the petition mainly, which actually challenged the rules and regulations. Now, friends, remember two things. Firstly, two notifications were challenged. Those notifications were under the Travancore Cochin Hindu Religious Institutions Act, as you can see it. And these two notifications totally prohibited the entry of women between ages of 10 and 50 into the Sabarimala temple on the ground that it was in contravention of custom and practice of the temple. So friends, basically ये जो दो notifications थे, ये दो notifications were issued under this particular act, that is Travancore Cochin Hindu Religious Institutions Act. अब ये दो notifications basically prohibit करते थे entry of women. वो prohibition में लिखा गया था, वो notification में लिखा गया था that as per customs of this temple, जो वुमेन 10 to 50 के एज ग्रुप में है, वो लोग कभी भी टेम्पल के अंदर एंट्री नहीं की है एज पर द कस्टम एंड प्रैक्टिस ऑफ द टेम्पल इन द पास्ट. क्योंकि ऐसा कस्टम और प्रैक्टिस चलते आ रहा है, ये दो नोटिफिकेशन जो आया था, ये दो नोटिफिकेशन सिंपली उस पर ठप्पा लगा दिया दैट since these custom and practice were continuing since past, thus the notifications prohibited this particular entry of women into the temple, thus reaffirming the custom which was already going on. They did not do anything new. They simply reaffirmed the custom and practice of the temple by attaching statutory force to it. Now, moving to the next particular regulation, friends, this was rule 3B. Friends, दो legislation हमेशा याद रखो, MCQ के भी important है ये. First legislation was Travancore Kochi Hindu Religious Institutions Act 1950, and the second legislation was Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965. एक है एक्ट, दूसरा है रूल्स. ये एक्ट के अंदर जो नोटिफिकेशन चैलेंज हुआ था और ये रूल्स में से रूल 3B जो है, दिस वाज precisely challenged in this case. And rule 3B did what? Rule 3B also barred women from offering worship in any public worship place or entry into places of public worship at such time if they are by custom or usage not allowed to enter such place. ये बेसिकली रूल 3B प्रोवाइड कर रहा था कि अगर कोई भी प्लेस ऑफ पब्लिक वर्शिप में बाय बिकॉज ऑफ कस्टम और यूसेज अगर कोई भी वुमेन को एंट्री नहीं है, तब उनको ये रूल के तहत प्रोहिबिट किया जाएगा कि क्योंकि आपको पहले से एंट्री नहीं है इस जगह पे, आपको अभी भी एंट्री नहीं मिलेगा. एज सिंपल एज दैट. तो बेसिकली द अर्लियर टू नोटिफिकेशंस and this rule 3B, they provided for the same thing. What? That because previously there was a custom has been going on, a custom or a practice or a usage that women, particularly of the age of 10 to 50, have not been allowed an entry into the Sabarimala temple. Thus, by law, they are now again prohibited. Earlier, it was only due to custom and practice. Now, the state has attached a legal force. It has supported this custom and practice and it has said क्योंकि custom चला रहा था तो custom के हिसाब से आज से भी आप और allowed नहीं होगे into the temple. This was the precise law. This was the precise rules and regulations which were challenged. So move to the next slide. Yes. Now coming to the judgments. These were all about the facts. Now basically आप याद रखिए because in CLAT exam as in this it was observed that even judges लोगों का भी MCQ में क्वेश्चन आ रहा है कि ये लाइन कौन से ऑनरेबल जस्टिस ने कोट किया था, ये कहा था. तो रिमेंबर कि सबरीमाला डिसीजन में there were 5 judges but there were 4 judgments. Why? Because Chief Justice Deepak Mishra was also giving the judgment on behalf of Justice Khanvilkar. तो दीपक मिश्रा on behalf of himself and Justice Khanvilkar दोनों के लिए कॉमन जजमेंट दिए, and Justice Nariman and Justice Chandrachud were also concurring opinion, and Justice Malhotra was dissenting opinion. So if you must remember this particular categorization. Now just seeing the particular point, the first point upon which Chief Justice then Chief Justice Deepak Mishra emphasized was that followers of Lord Ayappa do not constitute a religious denomination. Now, friends, religious denomination is governed by Article 26. Now, friends, अगर आप Article 25 और 26 को देखें, 25 focuses on individuals and 26 focuses on particular group of individuals which we call religious denomination or a section of that particular religion. ये जो रिलीजियस सेक्शन है इसका इंटरप्रिटेशन अभी भी चैलेंज में है कि इसका इंटरप्रिटेशन क्या होगा. तो लिविंग दैट अपार्ट बिकॉज वो हमारे केस के लिए भी रेलिवेंट नहीं है, फोकसिंग ऑन दिस रिलीजियस डिनोमिनेशन किसे कहा जाए, दिस वाज द पर्टिकुलर क्वेश्चन. एंड क्या लॉर्ड अयप्पा के फॉलोअर्स को भी रिलीजियस डिनोमिनेशन का दर्जा मिल सकता है? Can the followers of Lord Ayappa claim the status of a religious denomination so as to claim the benefit and privilege under Article 26 of the Constitution? This was the first question before the Honorable Court. And Justice Deepak Mishra held that they do not constitute a religious denomination. Friends, if you just see what are the criteria of a religious denomination. पहला चीज, एक collection of individuals, एक individuals का body होना चाहिए with a collective common faith as per their belief. तो बेसिकली देखो फ्रेंड्स, तीन चीज होना चाहिए. पहला है अ बॉडी ऑफ इंडिविजुअल्स, दूसरा है कॉमन ऑर्गेनाइजेशन, तीसरा है बाय डिस्टिंक्ट नेम. अब मैं एक एग्जांपल लेता हूं. आर्य समाज. आर्य समाज एक ऐसा संस्था है हमारी सोसाइटी में. आई गेस इट वाज एस्टैब्लिश्ड बाय स्वामी दयानंद सरस्वती. सो आर्य समाज का कुछ बेसिकली वो हिंदू फोल्ड को ही बिलीव करता है. हिंदू का जो ब्रॉड बिलीव्स है, जो ब्रॉड रिचुअल्स और जो ब्रॉड आइडियाज है, आर्य समाज उससे डिसेंट नहीं करता. बट आर्य समाज उसको कुछ और फॉर्म में बिलीव करता है. जैसे रामकृष्ण मिशन है. रामकृष्ण मिशन है वो भी बेसिकली, आज आप नाम से भी देख सकते हैं, राम एंड कृष्ण. सो यू कांट से दैट रामकृष्ण मिशन इज समथिंग आउटसाइड और डिफरेंट फ्रॉम हिंदू रिलीजन. बट रामकृष्ण मिशन is actually propagating Hindu religion in a different form, in its own understanding. मैं सबरीमाला जजमेंट पढ़ा हूं, मैं आपको एक तरीके से समझा रहा हूं. अगर आप पढ़ेंगे आप कुछ और तरीके से समझाएंगे, बट अल्टीमेटली हम लोग सबरीमाला जजमेंट को ही समझा रहे हैं. वैसे ही जो रिलीजियस डिनोमिनेशंस होते हैं उनका फर्स्ट क्राइटेरिया क्या है? जो कलेक्शन ऑफ इंडिविजुअल्स होगा, इट मस्ट हैव अ कलेक्टिव कॉमन फेथ व्हिच इज कंड्यूसिव टू द स्पिरिचुअल वेलबींग. ये तो कॉमन है. कोई भी रिलीजन का बंदा है, अगर दो बंदे हैं जो who follow one particular religion, they are having a common faith which is conducive to the spiritual well-being. So यहाँ पे अलग कुछ नहीं है. अलग यहाँ पे है which I have indicated in the brackets, that is something peculiar to themselves besides the broad beliefs, faiths or ideas of Hindu religion or any other religion of which they are a denomination. ऐसा कुछ beliefs, ऐसा कुछ ideas, ऐसा कुछ faith जो, अगर आप एग्जांपल लेते हैं हिंदू रिलीजियस डिनोमिनेशन, जो हिंदू प्रॉपर हिंदू आइडिया से थोड़ा हटके है, ऑल्दो उसका अल्टीमेट एंड वही है. हम जैसे सिंपली बोलते हैं कि सत्य एक होता है. कैन द मट्स बी, जस्ट लेट मी आंसर द क्वेश्चन श्रियंका हैज आस्क्ड, कैन द मट्स be then considered as religious denomination? Definitely, to understand which mutt is a religious denomination or not, you have to read the particular articles of association of that particular, because every mutt in society is a society registered under Societies Registration Act. So you have to read the articles of the society कि उनका articles में क्या specify किया गया है. Every mutt is a propagator of Hindu religion. But अगर वो ऐसा मठ है जो दूसरे संत संतों से या दूसरे मठ से कुछ अलग वे में हिंदू रिलीजन को प्रोपैगेट कर रहा है, then definitely it's a religious denomination. It can definitely claim the status of religious denomination. There is no separate registration that this particular mutt is a religious denomination. A mutt, when it comes to court, it has to satisfy these three criteria. And definitely, if the mutt is actually propagating and practicing Hindu religion in a way which is not common to other followers of Hindu religion, in a way which is a bit different from followers of other Hindu religion, so definitely they can claim the status of a religious denomination. In simple, और थोड़ा अगर मैं सिंपल कर दूं, अगर आप तड़का का जो डिश होता है देखेंगे, तड़के के डिश में राजमा भी होता है, तड़के की डिश में चना का दाल भी होता है, तड़के की डिश में बहुत चीजें होती है जो कलेक्टिवली तड़का का टेस्ट देती हैं, लेकिन उनका इंडिविजुअल अपीयरेंस भी होता है. आप वो सब्जी देख के जान पाएंगे ये राजमा है, ये चना का दाल है, ये वो है, ये है. सो रिलीजियस डिनोमिनेशन वैसा ही है. इनको देख के यू कैन नो that they ultimately are within the umbrella of Hindu religion, but the particular strings of umbrella are different. This is the first string, this is the fifth string. They are trying to understand, they are trying to propagate and practice Hindu religion in their own understandings, in their own ways. So I hope I'm clear with respect to what do you mean actually by a religious denomination. Okay, thank you. So the first point is actually very important to understand. The second, third point is very simple: a common organization, and again the third, एक distinct नाम होना चाहिए. जैसे रामकृष्ण मिशन, जैसे श्रीलंका ने कहा एक मठ, जैसे द फेमस केस शिरूर मठ, जैसे पुरी में एक है एमआर मठ इन ओडिशा, जैसे इन केशवानंद भारती केस द पर्टिकुलर मठ वाज I'm forgetting. There was again a particular mutt where Eri mutt. It was perhaps the name was Eri mutt. So the mutt has to have a distinct name, Ednir. Okay, yeah. Thank you, Omkar. Yeah, Ednir mutt. So it has a distinct name. Again, it has a common organization, and definitely the first point has to be understood in a well manner that something peculiar to themselves has to be there. So I hope I'm clear. Follow to the next slide. Okay. Now, Justice Deepak Mishra, he firstly laid down the criteria. Now he's comparing whether the criteria is fulfilled or not. So now you see, the follow all these are wordings of Justice Deepak Mishra's judgment itself. I have quoted the relevant paras and extracts. Yeah. The followers of Lord Ayappa do not satisfy either of these characteristics. So they cannot claim the distinct constitutional protection under Article 26. मैं अगर थोड़ा इसमें डीप जाऊं, एक दो आर्ग्यूमेंट्स था that Ayappans, okay, just wait. Sir, is MR Mutt Sukalayan has asked a question. Sukalayan, okay. Sir, is MR Mutt is not a religious denomination. See, again, I'm saying we can't generalize. If the MR Mutt is certainly a mutt which is registered, which must have been registered as a society under Societies Registration Act 1860. Now, if after reading the articles of association of that society, if it can be concluded, and MR Mutt का ऐसा कोई अलग practices भी नहीं है. If you see, MR Mutt is an extension of all those people who believe, who are followers of Puri Jagannath Mandir in Odisha, I'm saying. So MR Mutt is not distinct from the Puri Dham of Jagannath Mandir. Anything which is not that distinct from Puri Dham of Jagannath Mandir is definitely a part of the mainstream Hindu belief and something not peculiar or different from it. So on a general note, I can say that MR Mutt should not have been a religious denomination, but yes, if they can give evidence that they are following some practices, some rituals, or they have some ideas or beliefs which is very peculiar to themselves, then they can definitely, for example, अगर मैं केस का एग्जांपल दूं, आनंद मार्गीज, आप लोग सुने भी होंगे, इट्स अ वेरी फेमस केस. आनंद मार्गीज का दो सुप्रीम कोर्ट केसेस हुआ है जिनमें there was a common practice that those sadhus who were the members of Anand Margi religion, or so to say Anand Margi sect, we call it a sect. So Anand Margi sect members, they used to be naked, and being naked, they used to follow a procession in the streets with skulls in their hands, and with all those people who basically follow Shaivite religion, who with bhasma over their shoulders and hands, with skulls in their hands, like a agori type. So वो लोग आर्ग्यू किए थे that this is central to their belief as members of Anand Margi sect. Now the moment they say, because आपको पता है हिंदू रिलीजन में स्कल और भस्म लगाना ऐसा कोई, और नंगे स्ट्रीट्स में जाना इनके साथ, ये कोई कॉमनली बिलीफ नहीं है ऑल ओवर इंडिया. ऑल्दो स्कल्स और भस्म शिव जी का एक रूप है, एक अंश है, उनका एक इंडिकेशन देता है कि शिव भक्त है. But that does not mean being naked, wearing a mala of skulls, having skulls in one hand and bhasma over the shoulders, like Digambar Jains. You may say it. You may say it. So this does not mean कि all over India सब शिव भक्त वैसे ही करते हैं. So this was something distinct for the Anand Margi sect, for the members of the Anand Margi sect. So they claimed the status of religious denomination. So friends, there can be many examples. There can be endless examples, right? And we know that in Hinduism, even the famous Lord Adi Shankaracharya, he also had to argue with a lot number of mat adhikaris, mathadipatis, a lot number of sects, their members, their leaders, their scholars, to establish the supremacy of Hindu religion over the Buddhist prevalent school of thought at that point of time. So definitely Hinduism is all about Shastras, what we say, and there's a diversity within Hindu religion also. छठ पूजा बिहार में होता है, झारखंड में होता है, लेकिन छठ पूजा और कहीं नहीं होता. वैसे मारवाड़ी लोगों का गंगौर का एक पूजा होता है जो और कहीं नहीं होता. वैसे बिहू एक ये फेस्टिवल है असम में जो कहीं नहीं होता. तो religion is very diverse all over the country, and we can't say simply because one particular religious practice is followed in one particular area and not the whole country. That does not mean they are not Hindu, right? So it's very diverse in that nature. So that's why religious denomination का जो status है it becomes very important. तो इसीलिए सुप्रीम कोर्ट ने बहुत स्ट्रिक्ट क्राइटेरिया ले डाउन किया है. So moving further in this slide only, the Supreme Court held through specially Chief Justice Deepak Mishra that the devotees of Lord Ayappa, they argued that we are Ayappans. The devotees of Lord Ayappa, we all follow Ayappa and we are Ayappans. So Supreme Court also did a bit of research and it observed that there is nothing called Ayappans. We can say that he is a follower of Arya Samaj, he is a follower of Bodhi Samaj, he is a follower of Brahmo Samaj, or he is a follower of Ramakrishna Mission. They fall into those slabs, or we can say pigeonhole. But there's nothing called Ayappan. Ayappan is a very new name which is not known anywhere. So Supreme Court also held that this is not a distinct name as such. You are inventing it for the sake of argument. We have not heard as such. So Supreme Court held that followers of Lord Ayappa, they do not constitute a religious denomination so as to claim the benefit under Article 26. Now, moving further in this slide only, Sabarimala temple is a public temple, Supreme Court observed. It's a temple of public nature. That is, in general, public is allowed to worship. Moreover, friends, morality. If you can see, Article 25 and 26, all the rights under Article 25 and all the rights under Article 26 are subject to public order, morality, health. In Article 25, there is an additional requirement. They are also subject to other provisions of Part 3, whereas it is not there in Article 26. So, friends, morality, as interpreted by Chief Justice Deepak Mishra, also speaking on behalf of Justice Khanwilkar, he held morality means constitutional morality. Now, friends, there are two versions of morality: societal morality, constitutional morality. Whenever we encounter the term morality, like in 19.2, Article 19, Clause 2 also, there's a term morality, decency, morality. Now, here also, morality appears along with public order and health. Again, morality appears in lot number of areas. In IPC also, we have encountered the term of morality while judging the standard of obscenity in order to convict people under offenses of obscenity. In IT Act also it's there. So whenever we encounter the term morality in any statute or especially the constitution also, it generally seems that it is societal morality. But the court, even Justice Chandrachud has held that morality is constitutional morality. Whereas surprisingly, Justice Nariman has held that morality in Article 25 and 26 does not mean such constitutional morality, rather it means societal morality. So there's again a difference between judges in the same judgment. But so to say, if you take my opinion, definitely there can be disagreements. It's all about discussion and deliberation. As per me, morality means societal morality, because here morality has been used in the general sense. If you say public order, morality, health, this means, agar aapko pata hoga, there's a rule of interpretation called agetum generis. Yeah, there's a particular rule of interpretation called agetum generis कि 3-4 वर्ड्स अगर एक साथ हैं उनमें एक थीम चल रहा है, एक सिमिलर बैकग्राउंड है. अगर पब्लिक ऑर्डर is to be understood in the sense of common understanding, that is public. If health is to be understood in the sense of common understanding, that is public. Morality is also to be understood in the sense of values and mores of the society. Values and mores, because morality matlab hi common morality, and common morality means societal morality. तो constitutional morality जो यहाँ पे infer किया गया है, जो यहाँ पे interpret किया गया है, as per my opinion, I may be wrong as well, it is not directly reflecting the intent of the constitution framers. Agar constitution, because during the framing of the constitution, there was nothing called constitutional morality. ऐसा कोई term नहीं था. It's a judicial innovation. So morality, whenever a law is drafted, morality per se, it indicates, that means the common morality. That is public जिस पे commonly agree कर सके that this is moral, this is immoral. पर अगर उनको कॉन्स्टिट्यूशनल मोरालिटी इंडिकेट करना होता तो वो लोग कॉन्स्टिट्यूशनल वर्ड को भी लिखते उसके साथ, which definitely my opinion might be again subject to disagreements. I welcome it also, but it was my opinion. So moving to the next, yeah, just last point of this slide, just previous slide, please. This is the last point. Yeah, exclusion of women of any age group cannot be regarded as essential part of the Hindu religion. Rather, allowing Hindu women into temple is an essential part of Hindu religion. So यहाँ पे जस्टिस दीपक मिश्रा, चीफ जस्टिस दीपक मिश्रा also observed that जो women को exclusion का practice जो चलता है, that is not an essential part of Hindu religion. Rather, allowing Hindu women into temple for worship, it is rather an essential part of Hindu religion. This was the observation of Justice Deepak Mishra. Yeah, moving to the next slide. Yeah. What do you mean by essential part of religion? Now, friends, essential part of religion and non-essential. The first case, I guess I have not mentioned the case, but you must be knowing also. The genesis of this test of essentiality lies in Article 25, Clause 2A, and it was first time judiciary innovated in the case of Shirur Mutt. In the Shirur Mutt case, Commissioner of Religious Endowments versus Shirur Mutt. It was a 1950-52 case, 54 case, I guess. The year was 1952-54, and the main ratio of Justice B.K. Mukherjee at that point of time, he held that what can be said as essential to religion has to be ascertained on the basis of the doctrines of the religion itself. A court of law cannot directly read Quran in Arabic, directly read Bhagavad Gita in Sanskrit, and interpret itself that no, this is not essential, or yes, this is essential. The court has to again ascertain evidence that both the parties have to give evidence to the court that this is particular or essential practice of religion, this is not essential practice of religion. And on the basis of evidence, facts, scholarly opinion, the court has to rely and ascertain and adjudge whether a particular practice which has been contested or disputed in the instant case is essential part of the religion or is non-essential part of the religion. इस पे बहुत डिस्प्यूट्स हुए हैं, इस पे बहुत स्कॉलर्स जो प्रमुख कॉन्स्टिट्यूशनल लॉ स्कॉलर्स ऑफ द कंट्री इंक्लूडिंग एनएलयूज के वाइस चांसलर्स भी कुछ हैं जो अपना अपना ओपिनियन बहुत स्ट्रिक्टली इसको ले डाउन किए पब्लिक फोरम में, और ये बहुत कंटेस्टेड एरिया है. आई विल डेफिनेटली debate in this area in some other session, other video, or at the last of this video at least. But for now, you should focus on this particular para which I have indicated from the judgment of Acharya Jagdishwaranand Avdut versus Commissioner of Police. So if you can just read the para, that just follow the mouse cursor. The Supreme Court held that essential part of religion means the core beliefs upon which a religion is founded. The real test is to find out whether the nature of religion will be changed without part or practice. If the taking away of that part or practice could result in a fundamental change in the character of that religion, then such part could be treated as an essential or integral part of that religion. Nobody could say that an essential part or practice of one's religion has changed from a particular date or by an event. Basically, 1954 Shashwata has said. Thank you very much. The Shirur Mutt judgment. Yeah. So basically ये जजमेंट ये बोल रहा है दैट कोई भी रिलीजन का एसेंशियल पार्ट उसका कोर बिलीफ्स और कोर पार्ट से प्रैक्टिसेस होता है. ऐसा कोई प्रैक्टिस, ऐसा कोई बिलीफ, आइडियल, फेथ उस रिलीजन का जिसको हटा देने से वो रिलीजन का कैरेक्टर ही चेंज हो जाए, दैट इज एक्चुअल एसेंशियल पार्ट. और कुछ भी है जो जिसको हटा देने से रिलीजन का कैरेक्टर चेंज नहीं होता, या जो एकदम एसेंशियल कोर पार्ट नहीं है रिलीजन का, वो एसेंशियल पार्ट नहीं है. तो बेसिकली अगर मतलब एक बड़ा सर्कल है 10 सेंटीमीटर का, तो हाफ सेंटीमीटर का जो उसका सेंटर में है, जो उसका कोर है, वही एसेंशियल है. बाकी 9.5 सेंटीमीटर का जो बच गया है वो एसेंशियल नहीं है, आप अगर इसको ऐसे इमेजिन करें तो. Which I guess Shriyanka has said something like in a case where court said sacrificing cow and bakri is not an essential religious practice and anything else can also be sacrificed. Yeah, it was Justice Markandeya Katju's judgment, a 1952 Supreme Court judgment. It was with respect to this cow, yes, and he said state of Gujarat, I guess it was Allahabad High Court judgment, I guess. But Markandeya Katju was the judge in that case, and he held, yeah, Hanif Qureshi. right? Hanif Qureshi judgment, 1952 judgment. 1952, yes. Markati Karju quoted it in another case. Definitely, Markati Karju was not a judge at that time. 1952 Supreme Court judgment, and in that case, it was held that even in place of cow, you can also sacrifice a goat or a camel. That was the particular interpretation of the Supreme Court in that case, which again it is still criticized till date that after all, Supreme Court is not an institution who can infer from Quran what is to be sacrificed and what is not to be sacrificed. Some people also allege that Supreme Court has taken the level to judicial overreach in this aspect. But again, it's all matter of evidence. If the Supreme Court, I don't remember the evidence part of that case, if the Supreme Court has given this finding on the basis of evidence of scholarly opinion, of digests in that particular religion, of evidence or real practices also, that instead of cow you actually give goat or camel in sacrifice, you can give or you do so on regular basis, and definitely Supreme Court judgment is right, because it has not directly inferred it by on its own reading or its own interpretation. Rather, it has relied on the scholarly opinion itself or the religious opinion itself. So moving to this is the basic logic that essential क्या है वो उस religion का core है, और वो ये चीज सुप्रीम कोर्ट या कोई कोर्ट ऑफ लॉ खुद नहीं देखेगा. The court has to rely upon the evidence of scholars, evidence of the spiritual and scriptural texts, the scriptures, the text, उसके ऊपर rely करके उसको finding देना. So moving to the next slide. This was about the essential tenet test. Moving to the next slide. Moreover, the exclusionary practice has not been observed with yeah. So Chief Justice Deepak Mishra also observed कि ये जो exclusionary practice है, the practice of excluding women from entering into Sabarimala temple, ये practice continuous नहीं रहा है. ये बीच बीच में बहुत बार if you can focus with this word unhindered continuity, ये कोई अनहिंडर्ड कंटिन्यूटी से नहीं चल रहा है, हिंड्रेंस रहा है पहले. बीच बीच में फीमेल वर्शिपर्स ऑफ एज ऑफ 10 to 50 years used to visit the temple and conducted pujas in every month for 5 days for the first rice feeding ceremony of their children. ये होता था, और this was the evidence produced before the court. Court has not simply given a bookish observation. Court was given evidence by the chief tantri of the temple himself, by I guess the secretary of the temple also, that they have observed that women actually conducted pujas in every month for 5 days for the first rice feeding ceremony of the children. और भी एक दो जरियों से और दो तीन तरीकों से women did enter the temple. तो सुप्रीम कोर्ट has observed कि जो custom petitioners claim कर रहे हैं कि ये not petitioners, the respondent definitely, the state claim कर रहा है कि ये custom चले आ रहा है, ये custom चले नहीं आ रहा है with that continuity. तो fact जो जिस the basis of the argument of the state that the custom has been continuing since time immemorial, that argument is also flawed. In law, the state is flawed. In fact, also the state has got flawed. That they have been unable to prove a continuous exclusion of women into Sabarimala temple of this age group. So on both on fact and law, the respondent becomes weak. Now, thus the Chief Justice Mishra has concluded that Rule 3B is also ultra vires Section 3. Section 3 का एक प्रोवाइजो था that जहां पे रिलीजियस डिनोमिनेशन है, वहां पे अगर कोई कस्टम यूसेज ऐसा है जो वुमेन को एक्सक्लूड करता है, दैट इज परमिसिबल. दैट वाज अ प्रोवाइजो टू सेक्शन 3. बट क्योंकि एज जस्टिस मिश्रा हेल्ड अर्लियर that followers of Lord Ayappa do not constitute religious denomination, thus they do not get cover under the proviso to section 3. Thus custom or usage does not prevail, and thus rule 3B is ultra vires section 3 of the act. It's simple thing. It sounds a bit heavy. If you give one reading to this particular provision, it's in the case also. It's a very simple provision, 2 lines provision. You can absolutely conclude this point. Now, the third point, this exclusionary practice also violates Article 25 of the women followers. Definitely, Article 25 gives right to individual. It does not give right to man only. Women also are given the right to practice, propagate, and follow their religion. So, ये exclusionary practice जो है, it also prevented women, by preventing women from entering to the temple, it prevented women from exercising the right to practice and profess their own religion. So it is also violating Article 25. Thus, on a summary basis, that it is ultra vires section 3. It violates article 14, 25, both these articles. It is unconstitutional and arbitrary. This was the finding of two judges. Again, I want to just recall that this is not only the finding of Justice Mishra, this is the finding of Justice Mishra and Justice Khanwilkar. That this particular Rule 3B and both the notifications is unconstitutional and arbitrary. Moving to the next slide, please. Yeah, Justice Nariman, he gave a very short judgment in comparison to other judgments. That firstly, he said that there has to be harmonious construction of Article 25 2B and Article 26. Uh, it's a simple observation that Article 25 2B basically provided that कोई भी हिंदू religious temple या institution है which is of public character. अगर आप देखें जो अपार्टमेंट्स होते हैं, जो सोसाइटीज होती हैं जिनमें टेम्पल्स होते हैं, या जो हॉस्पिटल्स होते हैं जिनके कैंप प्रीमाइसेस के अंदर टेम्पल्स होते हैं, दैट्स नॉट अ टेम्पल ऑफ पब्लिक नेचर. Anyone who has a particular residence in a society or or anyone who is a patient or has some work in the hospital is entitled to that entry into that particular temple. That is not a public temple as such, because that is located within the premises of a particular what do you say, society or a particular hospital. It's not directly located on the road, but those temples to which public has general access, which is on the road itself or which is open for public in general, that is called a Hindu religious temple or Hindu religious institution of public character or public nature. So Article 25 clause 2 भी बोलता है that any temple which is of public character or public nature shall be open or should be opened for all classes and all communities of Hindus. कोई अछूत, कोई अनटचेबल, कोई छोटे जात का आदमी, उसको मना नहीं कर सकते आप उसको एंट्री के लिए और वर्शिप के लिए. दिस वाज द इंटेंट एंड दिस इज द प्रिसाइज प्रोविजन ऑफ आर्टिकल 25 क्लॉज 2B. बट आर्टिकल 26 जो है वो बोलता है कि रिलीजियस डिनोमिनेशन के लिए द राइट टू मैनेज इट्स ओन अफेयर्स इज अ राइट गारंटी टू रिलीजियस डिनोमिनेशन. कोई भी रिलीजियस डिनोमिनेशन अगर है और उसका खुद का टेम्पल है, तो that particular religious denomination has the ultimate right, the complete and absolute right to manage the temple, to administer the temple property, and also to manage its own religious affairs. So Justice Nariman observed that there might be an apparent conflict between these two provisions. एक बोलता है कोई भी पब्लिक नेचर का टेम्पल है उसको सबके लिए खोलिए, एक बोलता है कि जो रिलीजियस डिनोमिनेशन का टेम्पल है जो शायद पब्लिकली खुला भी हो, क्योंकि हर रिलीजियस डिनोमिनेशन ऐसा नहीं है कि वो अपने मेंबर्स के लिए ही खुला रखता है टेम्पल को. इट आल्सो अलाउज द टेम्पल फॉर जनरल पब्लिक वर्शिपिंग एंड जनरल पब्लिक एक्सेस. तो इन टेम्पल्स में देयर माइट बी कॉन्फ्लिक्ट बिटवीन द राइट ऑफ द रिलीजियस डिनोमिनेशन एंड the right of the public to have access to the temple in general. तो जस्टिस नरीमन said there has to be a harmonious construction और दोनों राइट्स को आपको इक्वली बैलेंस करना है. ऐसा नहीं कि 26 को पूरा वैल्यू देना है और 25 क्लॉज 2B को पूरा जीरो करना है, और ऐसा भी नहीं कि वाइस वर्सा. तो देयर हैज टू बी बैलेंस. जस्ट एज सिंपल एज दैट. दिस वाज द केस जिसमें जस्टिस नरीमन रिलाई किए, और he also held this particular logic that Sri Venkatramana Devaru versus State of Mysore. This particular ratio of having a balance between these two articles was firstly laid down in this case of Sri Venkatramana Devaru versus State of Mysore. Then Justice Nariman reiterated and reaffirmed this particular logic of having a harmonious construction between these two provisions. Okay, so moving to the next slide. Yeah. He also held, he did hold some 3 to 4 more points which were pretty relevant and pretty much important in respect of this particular case. Firstly, it is only the essential part of religion as distinguished from secular activities that is the subject matter of fundamental right under Article 25. Justice Nariman held that Article 25, which guarantees the right to practice, profess, and propagate religion, it gives the right to practice, profess, and propagate, not religion, only essential part of the religion, distinguished from secular activities. Now, this was the holding of Justice Nariman, and this is definitely a very subjective holding, a very debatable point which he held. He again said that superstitious beliefs, which are extraneous, unnecessary accretions to the religion, cannot be considered as essential parts of religion. Now, friends, superstition, religion per se means superstition. Superstition is something which is not real, which is not materialistic, or which is not visible, or which is not believable at the first instance. That is in the general meaning of what we understand as superstition, to which on which a person of ordinary sense and sensibilities cannot rely or cannot understand or cannot what do you say, have confidence in at the first instance. This is basically superstition. And if you say that superstitious beliefs which are extraneous or which are unnecessary, now what superstitious belief is extraneous or unnecessary again is not the work of the court. It is the work of the followers itself. It is the work of the clergymen of that particular religion वही धर्म के पंडित, आचार्य, मौलवी, इमाम, यही लोग हैं जो बोलेंगे कौन सा प्रैक्टिस, कौन सा बिलीफ अननेसेसरी है, इरेलीवेंट है, एक्सट्रेनियस है, या कुछ अनलिंक्ड है, लिंक्ड नहीं है मेन रिलीजन से. अ कोर्ट ऑफ लॉ कैन नॉट एडजज कि कौन सा रिलीजियस प्रैक्टिस इंपॉर्टेंट नहीं है, नेसेसरी नहीं है. ये कुछ ज्यादा ही हो जाएगा फॉर अ कोर्ट ऑफ लॉ टू इंटरफेयर इनटू रिलीजन. So this is very subjective actually, and this was also criticized because ये particular point was also held in the case of this this Ajmeri Sharif judgment, Durga committee, yeah, Dargah committee judgment by Justice Gajendra Gadkar. Justice Gajendra Gadkar in the Dargah committee judgment also held that superstitious belief which are extraneous or unnecessary accretions to religion cannot be considered as essential part of religion. This was heavily criticized because a court of law can, by no stretch of imagination, can ascertain what particular belief, practice, or ritual is extraneous, is unnecessary addition to the religion. This is the work of the clergy, not the court. Moving to the next point. Yeah, this is definitely this is very important. The term morality under Article 25 and 26 refers to that which is considered abhorrent to the civilized society given the mores of the time due to consequential exploitation. Okay, the important words are, if you can just focus, given the mores of the time. Mores means the values or the commonly held standards of the society. तो societal standards of behavior and conduct जो उस टाइम के हैं, according to that जो भी चीजें गलत हैं, that is morality. That will be the standard to judge कि कौन सा action moral है कि immoral है. So basically, Justice Nariman said these lot number of words, but the simple summary is morality means societal morality. This is the basic holding of Justice Nariman. So you can see this is absolutely different from what Justice Mishra held, and this is also absolutely different from what Justice Chandrachud will hold. So this is, he again said that this is not this particular followers of Lord Ayappa, they do not constitute religious denomination, and thus they're not entitled to the protection under Article 26. This was also the holding of Justice Nariman. Moving to the next slide. Yeah, here also he emphasized that Hindus of all kinds, actually Lord Ayappa devotees are not only from Hindu religion, even Muslims and Christians also visit the temple and worship Lord Ayappa. This has been observed in evidence. The court has got evidence of this particular fact. And the court said जिस deity को कोई भी धर्म के आदमी वर्शिप कर सकते हैं, डेफिनेटली दैट इज नॉट अ रिलीजियस डिनोमिनेशन. वो कोई रिलीजियस डिनोमिनेशन के एम्बिट में कन्फाइन हो ही नहीं सकता, बिकॉज दैट deity इज ओपन टू ऑल एट एनी टाइम. Thus, Lord Ayappa के followers जो हैं, they do not fall within a religious denomination, Article 26. Moving to the next slide. Yeah, these were the basic holdings of Justice Nariman. Now, this particular judgment of Justice Chandrachud is actually, which I would term, is the most significant judgment of all the judgments of all the judges. Out of the four judgments, Justice Mishra, Justice Nariman, Justice Chandrachud, and the dissenting judgment of Justice Malhotra, I would term this particular judgment of Justice Chandrachud as the most scholarly, most erudite, and most exam-centric judgment of this particular case of Sabarimala. Now, seeing all these points of law, you can just give a bare reading. It's very simple. He says morality means principles of justice, liberty, equality, fraternity. That is constitutional morality. He absolutely revolves around the idea of morality meaning constitutional morality. As simple as that. Yeah. Moving to the next slide. He also observed that the practice of excluding women from Sabarimala temple was not uniform. As I had said earlier, that practice of exclusion of women from this temple was not uniform. Thus, even if you claim that it's a customary practice, that is a false thing because you can't show it in evidence. Yes. Also, a member of any religion can be a devotee. Yeah, he also observed the same thing as observed by Justice Nariman, that also a member of any religion can be a devotee. Thus, devotees of Lord Ayappa cannot constitute a religious denomination. Yeah, moving to the next slide. Yes, the exclusionary practice is nothing but another form of untouchability. Friends, I'm sure if at all any question comes from this judgment, this area will certainly and absolutely have one question out of those MCQs. Because I have definitely summarized this point here, but I would at least recommend you that even if you don't read the full judgment, you must read this part of the judgment of Justice Chandrachud, where he holds that this exclusionary practice is nothing but in tandem with what we call untouchability under Article 17. He says कि the idea behind excluding women of the age of 10 to 15 is that because this age, women of this age are in the process of menstruation. And since they undergo the process of menstruation, they are considered impure, they are considered polluted. And because of this stigma, this mental stigma of women as polluted or as impure, thus they are abstained or they are restrained from entry into the temple and also consequentially restrained from the rights to worship Lord Ayappa. He says this concept of purity and pollution, if you can just see my mouse cursor, untouchability must be construed to include social exclusions based on notions of purity and pollution. So anything, any belief, any idea, any ritual which is whose edifice is purity and pollution, whose basis is the notion of purity and pollution, that is a discriminatory practice. Thus, he said, since women of age gap or age period 10 to 50 are undergoing the process of menstruation in regular intervals, and thus menstruation is associated with impurity and pollution by the Indian fold, in the Hindu fold of the society, thus they are to be treated as untouchables in this sense, to the extent that even some people confine these women who are going through this process of menstruation, they confine such women to a particular room in the house. They do not touch that those women for in some families. To this extent, this radical belief is there that they don't even touch or they don't even see such women who are undergoing the process of menstruation. Yeah, Sukalyan has some questions, sir. CGI says women between excluding group also go to the temple at a particular time of month. Now, this justice says they are untouchable. Sir, is not contradictory. See, Sukalyan, yes. Your question is a good question, but your question indicates that there's a conflict between fact and the argument. The fact says that women have been going to the temple. That is the flaw in the evidence given by the state. They are claiming that women have not been giving an entry. Women have not been going to the temple, going into the temple. So, by this observation that women have been going, their evidentiary argument gets flawed. It goes completely. Now, Justice Chandrachud says, even for the sake of arguing, now let us definitely on fact they are poor, but for the sake of argument also, when they say that by customary practice they are not allowed entry, on law also it shows that it is not valid. So, on the one hand, in the fact, they are not true because women have been given entry. Even in law, when they argue that customarily they are not allowed, in law, this argument is also flawed. Why? Because this customary, if at all, is there, then it is actually untouchability. I hope the doubt is clear. If Sukalyan, okay, indicates the previous slide, just for 1 2 minutes, 1 minute, the previous slide. Yeah. So I hope the concept is clear that, okay, the next slide. Yeah, fine. It's almost over. Yes. The next slide. Yes. The decision in the case of Narasu Appamani, this was regarding untouchability. So Justice Chandrachud held that this practice even for the sake of even by assuming that customers followed properly and they were not given entry, even assuming that this practice is not having constitutional validity because Article 17 is getting validated. As simple as that. Now the next point, the decision in the case of Naraswapamali versus State of Bombay is banned in law on two grounds. Friends, Naraswapamali is a Bombay High Court judgment. State of Bombay. I mean, Naraswapamali versus State of Bombay. It was a 1950s judgment, 1952 or 1950, I guess. And there were two. It was a two-judge bench judgment, a division bench judgment. Justice Gajendra Gadkar and Chief Justice Chagla, the then Chief Justice Mohammad Karim Chagla, I guess MC Chagla. Yes. So Justice MC Chagla held that there is a difference between customs and personal law. Personal law includes customs like Hinduism. Hinduism में everything is not from the Manusmriti, is not from the Vedas. हम लोग customs भी बहुत follow करते हैं. Hindu religion जो आज हम follow करते हैं as on date is a mixture of what has been written in Vedas, in Upanishads, in Smritis and in Shrutis, and also the customs. Even the same is the case in Muslim law. Everything, as we know, triple talaq, at least triple talaq जो अभी strike down किया गया as unconstitutional in 2017, triple talaq was un-Quranic, but it was prevalent as a custom. So even in Muslim law, everything is not traced from Quran itself, from the surahs and from the chapters of Quran itself. There are something called customs and practices which are not directly coming from the Quranic provisions. So every personal law includes customs, but personal law itself does not mean customs. It is not as same as customs. It is much wider. Customs is a part of it. So they are two different concepts and two different terms. And Justice Chagla held, since personal law is not appearing in Article 13 and Article 13 2A, and वहाँ पे दिया गया law includes customs and usages. Notifications order bylaws भी लिखा है. For the purpose of this case, I'm saying Article 13 clause 3A says that law includes custom and usages. तो वहाँ पे personal law include नहीं किया गया है law का definition में. So Justice Chagla held that since personal law is not mentioned in that particular provision, law simply includes customs and not personal laws. So Justice Gajendra Gadkar said that this distinction is not logical and it is frivolous. This was, if you can just read first point, the distinction made between customs and personal law is frivolous. Justice Gajendra Gadkar held it. And even this was supported by Justice Chandrachud in his own judgment. That's why I mentioned it here. And the second point also says that also in that case that person immune from constitutional scrutiny detracts from the notion that no body of practices can claim supremacy over the constitution and its values of dignity, liberty, etc. In simple sense, क्योंकि personal law का definition में नहीं है, and constitution is applicable only to law and nothing else. So personal law is outside the ambit of constitution, and thus personal law shall not be judged on the basis of the constitution or constitutional validity कि अब एक पर्सनल लॉ का आप कॉन्स्टिट्यूशनल वैलिडिटी कभी भी क्वेश्चन नहीं कर सकते. दिस वाज द अल्टीमेट रेशियो. व्हाई? बिकॉज पर्सनल लॉ वाज नॉट कवर्ड विद इन द डेफिनेशन ऑफ लॉ as defined in Article 13(3)(a). So Justice Chandrachud also observed that this particular holding of the Bombay High Court in that case, that because personal law is not covered in the definition of law, thus it is immune from constitutional scrutiny. This is very bad logic and very bad in law, because no body of practices can claim supremacy over the constitution and its values of dignity, liberty, etc. So I hope why I mentioned this judgment here, I mean Naraswapamali versus State of Bombay, because this judgment has always been seen in a bad light since the time it has been delivered. And in triple talaq judgment also, I would again recommend you to go through this part of the judgment of Justice Chandrachud, because this may also be a very good area of MCQ from the Sabarimala case. Why? Because Naraswapamali expressly argue किया गया था in the triple talaq, and Justice Sabarimala in that case held कि इस केस में, मतलब शायरा बानो केस में, ट्रिपल तलाक केस में, he said शायरा बानो केस में, ट्रिपल तलाक केस में जस्टिस नरीमन सेड कि इस केस में नरोसोपमली केस को विचार करने के लिए कोई रेलिवेंट नहीं है. Narosopamali case is not relevant in the instant case, so we are not giving any opinion on the validity of the ratio of that case. Subsequently, there might arise a further occasion in which the validity of this particular case can be questioned and can be discussed. This was the observation of Justice Nariman in the Triple Talaq case. Now, Justice Chandrachud in this case has expressly said that the ratio of this case is bad in law. So there are two judges in two recent judgments who have discussed about this particular case. So I would definitely say go through this part of the case while reading the Sabarimala judgment, and it's a probable area of MCQ in that judgment. Move to the, yeah, in this side only. Again, there was a argument कि deity in property law is regarded as a legal personality for the purpose of holding property and asserting property rights. So why not a deity is regarded as a legal personality in constitution? This was the argument given by the advocate, the famous one currently in these times, advocate J. Sai Deepak. He gave this argument that even the deity has its own right to privacy because women are going in the vicinity of a brahmachari, of a celibate god. And he himself has said in his own scriptures that I will always remain away from women and I will definitely abstain from any association from any kind of, from all kind of women. So women should not come near me, or at least I'll maintain some distance. So it's affecting the god's own privacy, this right to privacy, which is again Article 21. And because Article 21 applies to a person, that's why JSI Deepak argued that a deity for the purposes of property law is a legal person. And since at least here it is not here, definitely it is a legal person, that means it is a person. Thus, Article 21 is applicable to it. And since Article 21 is applicable to it, right to privacy is a right of that particular person, that is the deity. And since right to privacy is a right available to the deity, that means women cannot be brought to worship that particular god. Women cannot be brought in the vicinity of that particular god, and he has to maintain his own privacy. This was the ultimate argument of that of justice of advocate J. Sai Deepak in this particular case. But Justice Chandrachud expressly rejected this notion and held that Lord Ayappa is a deity for property rights. A deity is recognized as a legal personality only in case of property rights, and a deity is not a legal personality for all other rights or in itself. So in constitution, the deity is no person at all. This was clarified by Justice Chandrachud. So this is also a point of information which a student must have in mind to answer any question if at all an MCQ comes in the exam. Moving to the next slide. Yeah, thus the majority opinion has found that both the notifications as well as Rule 3B violates Article 14, 25(1), 21, menstruation as offending to dignity. Yeah, additionally 17 also. So you have to remember, friends, that 14 and 25(1) is commonly agreed between all the judges, Justice Nariman, Justice Kanvilkar, Chief Justice Deepak Mishra, and Justice Chandrachud. Whereas the question lies with respect to 21 and 17, Justice Chandrachud has added to this particular argument and has held that along with 14 and 25(1), 21 and 17 also gets violated. I have mentioned Justice Chandrachud only with respect to 21, only with respect to 17, but actually 21 also is held by Justice Chandrachud only. So in totality, ultimately these four articles are getting violated. Thus, this exclusionary practice is unconstitutional and set aside. This was the precise ratio of the majority opinion. I hope I have completed with the majority opinion of this case and I'm clear with the majority opinion. I know the time is running out, but if any very important question is there, you may definitely ask right now. Shriyanka is asking, are all idols juristic person? Shriyanka, definitely all idols are juristic person. They are treated as minors for the purposes of asserting property rights. And the Shebayat in property law, we have a Shebayat of every particular deity who is his or her, the deity's manager for earthly affairs. This has been laid down in the Shirumot case and various other cases. In the recent Ayodhya judgment also it was laid down. The Siddiqui case, that The Shebayat of a particular deity is the manager of that particular deity for all earthly affairs. And that deity is treated as a legal person, definitely not as a major, as a minor, for the purposes of all property transactions. Yes. Omkar is asking, in view of the CGI judgment, how to determine the essentiality of a diverse religion with multiple authorities? Exactly, Omkar, your question is the ultimate what do you say, jackpot in this realm of religion and constitution. And this question will ultimately open all the dicey areas of religion and constitution. But I'll answer your question uh, probably in the chat itself after the video gets over, because it's a very long question, and the since time is running out, I should focus on the minority opinion right now. But I'll only give an indication to you right now. My personal opinion. This question has not been delved into in any of the judgments by any of the judges. But this question is a very wide question. Why? Because especially Hindu religion, it's so diverse that Hindu religion, you can't say it is based only on Vedas, Upanishads, Smritis, and Shrutis. Hindu religion is so diverse that even individual customary, local customary practices also find a good place in Hindu religion. What happens within one district is also diverse. It's so diverse. So in such cases, definitely evidence has to be brought into the court, and the court cannot say that no, this particular practice is followed only in Jharkhand and not in the rest of India. So and also, since it is not directly written into the Vedas, Upanishads, Smritis, or Shrutis, this is not an essential practice. This is a very narrow version of Hindu religion, and I would definitely observe and comment. This would rather become counterproductive, because this will be an obstacle to the growth of a religion. This would be obstacle to the exercise of individualistic notions of religion. अगर कोई religious practice है जो मैं follow, दिवाली जैसे पकड़ लीजिए आप, दिवाली पूरे कंट्री में एक समान नहीं मनाया जाता, होली पूरे कंट्री में एक समान नहीं मनाया जाता, उसकी मेजोरिटी इज कॉमन, बट कुछ कुछ माइनर डिफरेंसेस रहते हैं जो रीजन वाइज डिफर करते हैं. तो जैसे छठ पूजा में पहले बोला, छठ पूजा बिहार और झारखंड में उनके लिए बहुत इंपॉर्टेंट है, लेकिन छठ पूजा और दूसरे एरियाज में नहीं मनाया जाता. इसका मतलब ये नहीं कि छठ पूजा इज नॉट एसेंशियल टू हिंदू रिलीजन. इट इज, एटलीस्ट इट इज एसेंशियल फॉर दोज पीपल हु आर फॉलोइंग इट. सिमिलरली उड़ीसा में एक पर्व है रज, जिसको हम बोलते हैं. इट इज एसेंशियल टू पीपल, हिंदू पीपल स्पेशली रिजाइडिंग इन दिस एरिया. उड़ीसा में एक और पर्व है जो दिवाली के बाद होता है, जिसमें हम कुछ नाव बहाते हैं नदियों में, पेपर के, कागज के, थर्मोकॉल के. वो भी एक एसेंशियल रिलीजियस प्रैक्टिस है यहाँ के लोगों के लिए. इवन मुस्लिम्स पीपल डू दैट. एंड आप अगर साउथ में चल जाएं तो उसके लिए और कुछ रिलीजियस प्रैक्टिसेस हैं. अगर आप असम में चल जाएं, जैसे मैं बोला बिहू है उनका उनका और है, और कुछ रिलीजियस प्रैक्टिसेस है. वैसे गंगौर, जैसे राजस्थानी लोगों के लिए गंगौर एक बहुत, which comes just before Ram Navami, I guess, in March or April. It is again an essential religious practice for them. So it is very diverse country, and we should not circumscribe and confine the growth of a religion to a particular a narrow view of the quote. That was what I want to say. So I hope Omkar has got some indication of the probable answer to his question. Definitely it's not the exact answer, and since time does not permit me, I cannot give him the exact answer, but at least I've given him an indication. Yes, Shashwata is right. It is called Kartik Purnima. जो मैं नाव बसाने का बात कर रहा था, it's Kartik Purnima. So moving to the, yeah, I have got the dissenting opinion on my screen. Yes. So Justice Malhotra is very clear. Justice Malhotra has not delved into any philosophical thoughts as Justice Chandrachud and Deepak Mishra have gone into. She is very clear on the face of it. Firstly, she has held that the PIL is not maintainable as the petitioners do not claim to be devotees of Lord Ayappa. She says in matters of religion, PIL is maintainable only when the petitioners are following that religion. If the petitioners are like NGO people who have just come to the court only on the sake of only for some concern out of their own some only for what we call out of mercy or concern for people who are unable to enter into Sabarimala, and they themselves have not been aggrieved, thus the PIL is not maintainable. So basically, PIL with respect to religious matters, Justice Malhotra has tried to re-adopt the notion of legal standing, the notion of locus standi, which was done away with by Justice Bhagwati to enlarge the ambit of PIL. This is also for a particular reason, because nowadays religion and religious practices are getting contested in a very myriad and in a very diverse and very what is augmented manner. बहुत बहुत पीएल्स फाइल हो रहे हैं, कोने कोने में फाइल हो रहे हैं हाई कोर्ट्स में, और उनके द्वारा हो रहे हैं जो अग्रीव भी नहीं है और जो उनसे प्रभावित भी नहीं है. तो unnecessarily religious questions are getting decided at the behest of those who have not even getting affected by that. So this is the intent to control the increase in litigation, to control the flooding of litigation. जस्टिस मल्होत्रा has held कि पीआईएल तभी मेंटेनेबल होगा जब पिटिशनर्स उस रिलीजन से अफेक्ट हुए हो या उस रिलीजन से रिलेटेड हो, तभी पीआईएल विल बी मेंटेनेबल. This was the first ratio of the dissenting judgment of Justice Malhotra, and thus Justice Malhotra held इस केस में जो इंडियन यंग लॉयर्स एसोसिएशन है, इनका पिटिशन इज नॉट मेंटेनेबल बिकॉज अल्टीमेटली इट्स एन एनजीओ सिटिंग इन दिल्ली. The case is in Kerala and they are an NGO sitting in Delhi, nowhere affected by this particular restriction on the women from entering to temples or worship to the particular Lord Ayappa. So this was the first ratio. Moving to the next ratio, which is the central ratio of a dissenting judgment. She says कि ये issue non-justiciable है. Non-justiciable मतलब cannot be adjudged in a court of law, cannot be disputed in a court of law. उसके लिए कोर्ट कोई रेमेडी नहीं दे सकता. That is called non-justiciable. तो इस केस में she said कि because religion is a matter of the clergy, religion is a matter of the particular followers of that religion and people who follow that religion, it is not for the courts to delve into it. You can follow my mouse cursor. She has said which would be outside the ken of the courts. See this particular phrase. She says judicial review of religious practices ought not to be undertaken, as the court cannot impose its own morality or rationality with respect to the form of worship of a deity. It would amount to rationalizing religion, faith, and beliefs, which is outside the ken of courts. So, friends, this was the particular ratio she said, and that's why in the next slide, if I can just go to the next slide, she said that yeah, the next slide, please. Yeah, she said. Yeah, each individual is at liberty to hold his own religious beliefs, however irrational or inconsistent they may seem to some, however surprising. कोई भी बिलीफ, कोई भी रिलीजियस प्रैक्टिस या फेथ या आइडिया या रिचुअल किसी को भी कितना भी इरेशनल क्यों ना लगे, कितना भी इनकंसिस्टेंट क्यों ना लगे, अगर वो इंडिविजुअल का खुद का बिलीफ है, आइडिया है, फेथ है, दैट इज प्रोटेक्टेड अंडर आर्टिकल 25 and you can't question it in a court of law. As simple as that. So she said that rationality of religion cannot be a subject matter of dispute in a court of law. As simple as that. And it is the subject matter actually of the clergy. वो मौलवियों अपने क्या उसको बोलते, इमाम, मौलवी, उलेमा, इनका मैटर्स है. वो पंडित, पुजारी, आचार्य, शंकराचार्य, इनका मैटर्स है. वो कोर्ट्स ऑफ लॉ का मैटर्स नहीं है कि ये सही है, गलत है, या ये रैशनल है या इलॉजिकली इरेशनल. एज सिंपल एज दैट. नाउ द लास्ट रेशियो she said and she held the practice of celibacy and austerity is the unique characteristic of the deity in the Sabarimala temple. वो बोली she said she held that Lord Ayappa, who is the deity in the Sabarimala temple, he is a celibate and he has an austere attitude. That means he will abstain from the company of a woman. He is a celibate and he is austere. Is an austere deity. Austere means strict, with the unique characteristic of being a celibate. The form of the deity in any temple is of paramount importance. She says जो temple के लिए आपका right आप claim कर रहे हो, the right depends upon the nature and character of the temple. And that's why since the temple's character is itself abstaining from women, so women can't have a fundamental right. They can't have a fundamental right to worship, because the very existence of the temple would then become dubious. अगर टेम्पल के जो डेटी हैं जिसको आप वर्शिप करना चाहते हैं, वही अगर आपसे दूर रहना चाहे तो वो वर्शिप का कोई मतलब नहीं, देन वो आपका मनमानी है. This was the particular understanding of the dissenting judgment of Justice Malhotra, and she said, since the form of the deity in any temple is of paramount importance, in the present case, any interference with the mode and manner of worship would impact the characteristic of the temple. फिर वो ब्रह्मचारी नहीं रह पाएंगे, फिर वो सेलिब्रेट नहीं रह पाएंगे, and that would have a counterproductive effect on the practices and beliefs of other worshippers. जो क्योंकि आप अगर सबरीमला में एंट्री करके आ रहे हैं और जबरदस्ती लॉर्ड अयप्पा को वर्शिप कर रहे हैं, तो जो लॉर्ड अयप्पा को सही में मानते हैं और जो सही भक्त हैं, जो सही डिवोटी है, उनका राइट टू रिलीजन आप अफेक्ट कर रहे हैं, आप इन्फ्रिंज कर रहे हैं. This was the angle with which she discovered this particular ratio and she held it as such. She said कि by entering the temple, by breaching the fundamental characteristic of the temple, you are actually breaching the religious right to practice, profess, and propagate this right to what do you say, to practice this religion and to devote oneself to Lord Ayappa. You are affecting this right of other people. जो ना वुमेन है, जो मैन है और जो कैपेबल वर्शिपर्स. तो आर्टिकल 25 उनका वायलेट हो रहा है अगर आपका आर्टिकल 25 देखा जाए तो वुमेन का. दिस वाज द पर्टिकुलर टोन ऑफ द जजमेंट ऑफ जस्टिस मल्होत्रा. मूविंग टू द नेक्स्ट स्लाइड, आई गेस इट्स द लास्ट स्लाइड, द नेक्स्ट स्लाइड. I hope it's the, I guess it's the last slide. Article 14, I have just summarized the particular holdings of Justice Malhotra. Article 14 does not override the fundamental right under Article 25. Now this is a bit contradictory because Article 25 specifically बोलता है that just the last slide please. Yeah, this slide. Okay, this slide. Yes, this one. Article Article 14 does not override the fundamental right under Article 25. Article 25 specifically says it is subject to public order, morality, health, and other provisions of Part 3. Now, other provisions of Part 3 में Article 14 भी आता है. So this is a bit contradictory, definitely, and that's why dissenting opinion of Justice Malhotra, because it is strictly worded and it is very harshly toned judgment, and also because of this particular holding, which is contradictory, that Article 14 does not override the fundamental right under Article 25. इन दो तीन कारणों से the dissenting opinion is also criticized in the academic world. Now the next issue, the Ayappans satisfied the requirements of being a religious denomination and thus entitled to protection under Article 26. ये भी was held by Justice Malhotra. The limited restriction on entry of women of age group 10 to 50 does not fall within the purview of Article 17. She held absolutely opposite of what was held by Justice Chandrachud, and definitely this is also one version and one another logical version of that particular aspect and perspective. So both, you can definitely have both perspectives or either of them. The last holding and the final holding, that is Rule 3B is not ultra vires Section 3 of the Act, because the proviso to Section 3 exempts religious denominations and devotees of Lord Ayappa constitute religious denomination. तो क्योंकि दे कंस्टिट्यूट रिलीजियस डिनोमिनेशन, सेक्शन रूल 3B इज वैलिड, क्योंकि रिलीजियस डिनोमिनेशन के केस में कस्टम इवन द कॉन्ट्ररी इट इज सपोर्टेड बाय लॉ, इट इज सेव्ड बाय लॉ, एंड बिकॉज यहाँ पे कस्टम इज सपोर्टेड बाय लॉ, तो रूल 3B इज नॉट अल्टरवाइज, as simple as that. So I hope I'm clear with the judgment. I have also covered the minority opinion, the dissenting opinion. So after completing this judgment, definitely we have come to the end of the judgment. Just I want to make a simple observation that when you read the Sabarimala judgment, it's a very hefty judgment, very heavy judgment, but I have tried to cover all the central holdings of all the judges. Whatever I have not covered is something which is additional. So I expect that whatever MCQ will come in the exam, if at all Sabarimala judgment comes, and mind, just remember it, that this is the first case in the series. We have more two judgments, rather one judgment and another order. The Kantaru Rajivaru judgment, that is the first review judgment, is a judgment proper, and the second one, that is the third one in the series, is an order, which is the 9-bench order, which has been constituted, and the order is only a one-page order which has just framed 7 questions of law. As simple as that. So keeping in mind the importance of this first case in the series, I would like to just say, whatever I have said in the judgment, please go through it again in this video, go through it again, and in 2 to 3 areas I have just specified that at least read this area of the judgment in entirety, like Justice Chandrachud's untouchability, and also Narasu Apamali area of Justice Chandrachud. I would rather recommend, if you can do, read the full judgment of Justice Chandrachud, because that will also help you in subjective answer. I'm sure next year's CLAT will have subjective area, And Justice Chandrachud's judgment are so erudite and so rich in language and literature that it will help you in writing subjective answers. And definitely, he has covered two very important points: Narasu Opamali case and untouchability, this exclusionary practice amounting to untouchability and thus violating Article 17. So, please read in entirety the opinion of Justice Chandrachud. This is my sole recommendation. If you can read the whole judgment, it's very well and good. Just entertaining some last doubts. Akanksha has asked one. Sir, I want to ask one thing, that this is the first time in which we have to go through the whole judgment. Can you give some suggestions how to read the lengthy judgments? Akanksha, see, what I did, I'm sharing a personal experience. I did not see any time. I just delved into judgment very deep. What I would recommend is first read the summary of the judgment. So do one thing. If you can access SCC online, or if you can access SCC reports of the judgment, first go through the SCC report, the summary of the judgment. Every SCC, every judgment which is reported in SCC report has its own summary, and that is the most authentic summary. So if you can access SCC online or SCC reports of any Supreme Court judgment, please access it and first go through the summary of the judgment provided in that report. Once you go through the summary, you can know which area in the summary which has been covered is important or not important, because summary will itself indicate which area is important or not important. Anything which is not mentioned in the summary, I'm not saying is not is absolutely unnecessary, but it is not that important so as to be covered in the summary. I followed this pattern. First, I saw the summary, and if by seeing the summary I become satisfied, yes, these areas I have to read, I did not read the whole judgment. I only covered those aspects mentioned in the summary in the full judgment. But if, like I felt in the case of defection judgments, this year many defection judgments have came, and the defection judgments summaries were not apt to the point. So I felt a need to read the whole judgments. So what I would say, fix a daily target. What the daily target should be completing one judge's opinion. Every judgment has 3 to 4 judges or 5 to 6 judges on the bench. So try to have a daily target of completing one judge. If you have a daily target to completing one judge, you can finish 500 to 600 pages judgments in 4 to 5 days. As simple as that. Average, you have to give 7 to 8 hours per day for reading a judgment. And believe me, no summary on Google, whether you type anywhere in Google, no summary will give you that material which the entire judgment will give. Because you have to understand, you will have subjective portion in your CLAT. And for subjective portion, you need that strength of literature, you need that acumen of language to support your answer. And that will only come